Whenever I evaluate a personal injury case with a client, there's different parts we have to look at. Part of the case, and when we look at what it's worth, the value comes down to 3 areas that you'll probably hear about if you watch other videos. Number 1 is who's at fault. 2 is what did a person go through? We call that damages legally. And 3rd are insurance issues. Let's talk about those first 2 right now and how they connect. When we look at who's at fault, at the end of the day, if the case would go all the way to a trial, which is rare, but it does happen, the jury may be asked whether driver A is at fault or driver B is at fault. If they say both are at fault, then the jury is asked to make a comparison, and they do this by percentages. Those percentages in that comparison impacts the what is it worth to go through what my person went through, the damages column. To make the math easy, if a person has $10,000 in damages, the jury says your injury claim is worth $10,000. And the jury also said, I think you were 20% at fault because you were speeding. That 20% reduces the $10,000. So if my plaintiff is 20% at fault on a $10,000 damage case, I can collect $8,000. If my person is 40% at fault, I can collect $6,000. It works that way until generally 50-50. There are some more complicated cases in which there may be 3 or 4 different actors we're evaluating, and I can review that with people. Once my client's 50% at fault and the other person is 50% at fault, my client collects half their damages. If the plaintiff is 51% at fault, the plaintiff collects 0. This is called modified comparative negligence. Other states may have pure comparative negligence, but this is the law in Wisconsin. We compare what percentage of fault is assigned to a person, and when it's the plaintiff, that reduces their damages. So we have to evaluate both those factors in looking at what's a reasonable resolution and settlement value or verdict in a case.